welcome to this week's edition of Wednesday Wisdom. My name is JB Hilliard, and these are weekly video segments that are an extension of our monthly newsletter called Sidebarred. And if you're not familiar with that, you can sign up right here and see what that's all about. But for this week's Wednesday Wisdom, I thought I'd talk briefly, kind of a continuation of a previous discussion on real estate and real property. I thought I'd continue that and talk this week about the different types of deeds. So a lot of you out there are probably very well versed in quitclaim deeds, or have heard those terms, quitclaim deeds, or limited warranty deeds, or special warranty deeds, or general warranty deeds. So I just want to talk very briefly about some of the main difference between those. And that is, so let's say a lot of people, I know you guys are do-it-yourselfers out there and very sophisticated folks. And a lot of times you want to do a quitclaim deed when you're transferring title to another person or adding a person to a title. But just be aware, particularly if you're on the receiving end of that, you're the grantee and not the grantor is a person signing off the title to you. So if you're the grantee, you want to pay particular attention to what type of deed you're receiving that grantor is signing off over to you. Now, a quitclaim deed is not warranting anything. Basically, in essence, a person can give you a quitclaim deed and not even own the property. And that has happened. So you want to be very careful. They're not warranting anything. Whereas with a limited warranty deed or even a special warranty deed, that person, that grantor, is at least warranting that the title is free of defect during the time that that person, that individual, the grantor, has held the title. So if I've had my house for, let's say now it's almost 9 years, so I'm warranting to you that during that 9-year period, that time that I've held the title is good. Now, and so that's a good thing. That's much better protection than a quitclaim deed as the grantee, the person receiving. Now, the ultimate protection, and a special warranty deed does the same thing as a limited warranty deed during the time that I've held that, or during a particular time. Now, a general warranty deed, when you're looking at the history of the title or the history of the ownership, typically you're going to see that at the very start of this whole thing, when the property was actually developed, or when the home was built, and the builders or the developers are the ones giving you the general warranty deed, and that warrants the title is without defect both during the time that owner has held title and before. So from now and hence all the way back to the beginning, that title is good. They're warranting that title has no defect. So that's great. That's the gravy. But you don't see a lot of those once the title starts shifting hands or shifting ownership. You don't see that general warranty deed provided as much to the grantee. But you still want to be careful about those quitclaim deeds, okay? So that's all I have for this week, because I have some pizza in the oven and I don't want it to burn, so let me go check on that. And in the meantime, as always, I thank you for watching, and we'll see you next time.